This week on Rochelle's Daily Wire Video Edition, we're going to talk about a case where the U.S. Supreme Court ducked making a decision about two very important Chapter 11 issues. The petition for certiorari came from the Third Circuit in a case called Millennium Lab Holdings. That decision from the Third Circuit, late in 2019, raised two gut issues involving Chapter 11. Number one, does a bankruptcy court have the power to issue what are fondly known as non-consensual third-party releases? And number two, does an appellate court have the right to refuse to rule on the merits of an appeal from a confirmation of a Chapter 11 plan under the judge-made doctrine of equitable mootness? Well, as I said, the Supreme Court ducked those issues by denying certiorari this week. But when you look closely at the case, I think we can understand why that happened and why they won't be reaching those issues, at least in this case. First off, on the question of third-party releases, the decision, as I said, came from the Third Circuit. And that circuit, because it presides over Delaware, is, I think, the most sophisticated of the circuits when it comes to Chapter 11. And with regard to third-party releases, the Third Circuit was very careful to say that they were approving those releases only because there were exceptional circumstances, and indeed exceptional they were. The people who got the third-party releases in the Millennium Lab case had contributed $325 million, yes, $325 million, to the Chapter 11 plan, and in the view of the Third Circuit, that was sufficient to give them non-consensual releases from third parties' claims. And when it comes to equitable mootness, it is notable that all of the circuits to have considered the issue will allow for dismissal of an appeal for equitable mootness. And so on that score, there is no circuit split. And as we know, the Supreme Court is not likely to grant certiorari unless there is a circuit split. And as I said, on the question of third-party releases, the court said there were exceptional circumstances. And so that means that the Supreme Court would be not likely to rule on what was an exceptional case as opposed to an ordinary case. Also, by the way, I have to note that if you'll think back over the last 10 or 15 years, the Supreme Court is most likely to take bankruptcy cases that involve consumer bankruptcy in Chapter 7 or Chapter 13. And to my way of thinking, the Supreme Court, I believe, has the view that the Chapter 11 process really works well. It's one of the best programs in the entire federal government. And I believe the Supreme Court, because they know their experience with Chapter 11 is limited, are afraid of jumping into Chapter 11 and messing up a system that really works. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. We'll be back same time next week with something else interesting that has occurred in the area of bankruptcy. Until then, be well, stay safe, Zoom with your family if you have to, but come back next week, and God bless you. I hope nobody out there incurs this horrible disease. So be well, good day, see you next week.